You're representing yourself in court on an interim motion or application in your divorce or family law case. Here are some tips. This may sound obvious, but on the day of the appearance, show up to the courthouse early. Find what courtroom you're in. Once you get to the courtroom, see if your ex or their lawyer, if they have a lawyer, is there, and say hello to both of them. Set a pleasant tone for the rest of the day. Because you're in court on an interim matter, it's likely that there's going to be other matters set on a list, what we sometimes call a chambers or docket list. So there's likely to be other people who have matters in the same courtroom. This means there'll be a list of those matters posted either outside the courtroom or at the front of the courtroom where the court clerk is seated. Go and find the list and find what number you are on that list. It's likely the court's going to work down the list from number 1 to whatever number of matters there are on that list. If you're the last matter on the list, it's likely you're going to be sitting around the court for some time before your matter is called. Once your matter is called, you're going to go to the front of the courtroom, and when the judge asks you, you're going to state your full name for the record. If you're the applicant, the party that's applying for some orders that day, it's likely that you are going to be asked to make your submissions first. Now, when you start your submissions, if you're the applicant or even if you're the respondent, state to the court very clearly, what do you want the court to do that day? What relief do you want? What orders do you want the court to grant at this court appearance? Next, tell the judge why they have the authority or the jurisdiction to grant the relief that you're asking them to grant that day. This might come from statutes like the Divorce Act or your Family Law Act, or it may come from case law. If you have those relevant sections of the legislation or the case law handy, cite it, point it out to the judge. Lastly, in a succinct and chronological manner, point out to the court all the relevant facts that support why you should get the relief that you've asked for at this court appearance. After these submissions are made, it's likely the judge is going to make some decision on the application right then and there, but sometimes they reserve their decision and will call the parties back to the courthouse at a later date to issue the decision. Now, regardless of the outcome of the application, if you follow this process by being polite with the other party and their lawyer if they have one, and being logical and respectful in your submissions to the court, you can leave holding your head high. Good luck on your application.